We are on. Hello, Mane. How are you?
Hi, Don. I'm good. How are you?
Great, great. So we're going to do a little case review today, and because you're such a brainiac, I gave you probably the most difficult case thus far this year to look at, because this involves a lot of detail concerning a dispute with regard to the distribution of an estate after somebody dies. There's some siblings that are going at it. We're not going to get into the detail about that. If Allie was here, she could chime in on it. But since we're family law attorneys, we're going to talk about the family law portion. And this case, like a lot of cases, has crossovers. You've got, a probate issue. None of those issues really were on appeal, but then it crossed over into a family law. So it should be interesting. And I think I'm going to call this case, it's not a game, right? Going to trial in litigation is not a game. It's not about hide and seek. It's about seeking truth, good advocacy, but never, trying to fool the judge, and especially in family law. So I don't want to give it away up front, but why don't we talk about the name first? What's the name of this case?
So the name of the case is Nakamoto versus Sue,
Okay.
which is the dissolution case. And then third parties were brought in, and they're known as the claimants or Bryan Corporation.
Yeah. So there were siblings that were brought into the case, as well as a corporation.
Correct.
And we won't deal with joinder of parties and everything in this podcast. Yeah. It was an Orange County case, right?
Yes, Superior
Okay.
Court of Orange County.
Okay. So why don't you set up the facts loosely with respect to, before we get into family court. I know we don't want to go through a bunch of the details, but basically somebody dies, and we've got siblings that are fighting over property, right?
Sure, yeah. So the husband in the case, the appellant, his name is Daniel Sue. Mr. Sue and his siblings had wealthy parents who had done really well for themselves, and they owned a couple of businesses and a substantial wealth, a few $1 million when they passed. So I guess Daniel wasn't the favored sibling. He was always getting in disputes with his other two siblings and things like that. And
Two sisters?
I think it was one brother and one sister.
Okay.
Yes. So the main dispute was regarding this handwritten agreement that they had signed, which Daniel, the husband, claimed they agreed to give him $4 million in addition to all this other stuff for him to just kind of go away and stop fighting with his other two siblings.
Okay. So we got that. They're fighting over the validity of the handwritten agreement.
Yes. So
Okay.
what happened was they met one day, and a third party, a mutual friend, was kind of mediating. The three siblings met, and they came to an agreement regarding various terms. And they entered into this handwritten agreement that was partly in Chinese, partly in English, and it was signed. And later on, there was a formal contract that was drafted, which everyone signed, and it differed in terms of the contract didn't have a similar clause where it said Daniel was supposed to get $4 million, and that was where the dispute arose.
Okay. And there was a translation in court we'll talk about later on of this document, the Chinese portion of it, right?
Yes, and it was very, even the translation was very I don't know if this would even stand on its own, because it was so ambiguous, I think.
Okay. How does this thing wind up in family court?
That's what I was wondering when I was reading it. So the context in which this came up was Daniel, the husband, his wife, Christine, files a dissolution, and the $4 million. So husband and wife actually were in agreement on this issue, because should the $4 million, should that be a valid contract, that meant this was a community asset. So that means the wife would have gotten a portion of that.
Okay. And before we get too deep into the family law case, my understanding is initially the husband in this case was going to get some other properties, and he made an agreement with his siblings to get basically bought out, and that's what this contract was for. He finds himself now in divorce court because his wife is unhappy with him, but she agrees that, hey, it's in our interest to try to get this $4 million. So even though we're divorcing, we're on the same team against your siblings in the corporation. So they do what we call joinder. They bring these people into the family court. So we're outside of the probate court now. We're in the
Yes.
family court.
Yes, I thought that was interesting that the family court held a trial on the validity of this handwritten agreement, and a trial that lasted, what, like a week?
At least 5 days or something. Yeah.
I think they estimated 4 days, but it ended up lasting 7 or 8 days.
Okay. Okay. So the trial goes forward, and the part of the issues that were contested, as I read this decision, is that Daniel was challenging documents. Right? He was arguing that they weren't authenticated. He was arguing against a translator's translation of these documents and other things. Why don't you go into a little bit more detail about what the dispute was?
Sure, yeah. He was challenging, like, another thing was that, I think it was China, or it wasn't the U.S. They use medallions to verify someone's signature on a legal document, and he was contesting that these were valid medallions, that he signed them, only to waste a few days of trial and then later just say, yes, fine, I admit that was my signature.
So he was contesting his own signature on a document.
Correct, which
Okay.
caused, trial to extend by 2-3 days because they had to bring in
Handwriting experts and
right, translators and all sorts of people to, in the end, only to say, okay, I concede that was my signature.
right. So he starts off by trial challenging something that would be like, man, you're basically accusing your siblings of committing fraud here. Somebody signed it but you, and you lead this court on this path to think that maybe this happened. Now we've got to listen to the evidence, and once it's proven, then he
Yeah.
concedes the point during the trial.
Wasted money, judicial time, resources, all sorts of things. And the reason these contracts and things were being brought in by the siblings is because what the siblings were, the position they took is, no, there was never supposed to be a separate clause where he got $4 million. This $4 million came from various properties that he was supposed to get, and we had agreed that $4 million was, the fair value of this property, and that's all he was supposed to get, not an additional $4 million.
Okay. So what happens is at the end of the case, the Daniel, actually during the midst of the case, he got some attorney's fees, right, paid to him?
Yeah, so that was new to me. I wasn't aware that, I'm aware of Family Code Section 2030, which basically says, it determines if someone has the ability to contribute to another person's fees, who might have the need for those fees. And I didn't know that these fees could be awarded from third parties that are joined in the action. I thought it was only between the two spouses. So number one, I wasn't aware that a third party could be on the hook for paying 2030 fees.
This case could be cited for that purpose. So
Yeah.
if the shoe were on the other foot and the third parties were behaving inappropriately during the trial, once they're joined in, either under 271 sanction, which is you're doing something bad, or even need an ability, a third party who's not getting a divorce but's been joined in could be subject to paying for attorney's fees.
Yeah, I thought that was interesting. But yes, so during, even before this trial, they, both husband and wife were awarded substantial amounts of money. I think he got like 140 and she got 150 or something to that effect already, paid by the corporations, the third party.
So the corporations were ordered by the family court to make an attorney's fee award to Daniel during the process of the trial, or
Correct.
before, during, or whatever it was. But he already got a substantial amount of attorney's fees paid.
Yes, and they both got an additional $10,000 during the trial, I think.
Okay. Okay. So the trial wraps up, and what does the judge decide in this case?
It decides that the written agreement was not a valid contract, and
Daniel loses.
he loses.
Okay.
Yes.
What else?
And then so Daniel, number one, appeals that, and number two, makes a request for additional fees to be paid to him under the family code, and the court denies this request for additional fees, and the appeal, I believe, is also, the appellate fees are also denied.
Right. And I think that at the conclusion of the trial judge says, this wasn't even a close one.
Right. It didn't cause him to even think twice about it. It was so obvious that the handwritten agreement was not a valid contract and it wouldn't stand on its own.
So Daniel asked for more fees.
Yes.
What happened there?
It was denied, and the court went through an analysis of Section 2030 and discussed how it's not just need and ability, but unfavorable trial tactics that would cause someone to lose on this request, which is what he did. He extended the trial by numerous days because he was contesting valid signatures and bringing in third parties and contesting translations, which were valid, and things like that to drag the trial.
So what we learned from this case is that the 2030 of the Family Code doesn't only deal with need and ability to pay. That's usually where we start when we're looking at if somebody's going to get attorney's fees from the other side.
Mm-hmm.
We tell our clients all the time, you want attorney's fees, but unless we could show that they have the ability, you might not get them.
Mm-hmm.
You probably won't get them. And if you've got just as much ability to pay as the other side, you're probably not going to get them. And we kind of usually stop there. We do an analysis of the 4320 factors under the Family Code, but usually it's about need and ability. But there's one more component that's rarely mentioned, and that's reasonableness of the fees. Was it reasonable for you to take up the court's time and to sock the other parties with a bunch of attorney's fees on their own because you decided to have a little play date in court that's going to last 5 days, right?
Over litigation and trial tactics. We forget that, but it's a big one in this case, especially.
Yeah. Well, Daniel doesn't like the decision, does he? He brings it up on appeal again.
He does, and he loses again.
Okay. What does the Court of Appeals say?
So the court, as I was saying, it goes through 2030, and it addresses, number one, the fact that Daniel, in his brief to the appeal court, didn't really discuss at all. He was trying to relitigate why the handwritten agreement was a valid contract. He didn't do anything to show why the trial court had abused its discretion in denying his request for fees, which is what you're supposed to do on the appeal, to show that the trial court, made the wrong decision because they misapplied the law or they didn't consider the correct facts, things like that. He failed to do that. So the Court of Appeals agreed with the trial court and said that, you did in fact drag on this trial, and he was trying to blame the other side, or no, they are the ones who dragged it on, and the Court of Appeals didn't fall for it.
Yeah, it's interesting. I see it so many times in our appellate court decisions that people that appeal think that's an opportunity to retry the facts, right? And the standard's not that, is it?
No, the facts are not reviewed, especially with the abusive discretion standard, which is the lowest standard. The court doesn't re-examine the facts, so what he did was completely inappropriate.
Yeah, you're going to lose automatically. You get up there and you go, well, the judge made the wrong finding with regard to a factual issue. Sorry, you lose on that. You're really going to prevail if you could think if there was a misuse of the law. That's normally when these decisions are favorable to the person on appeal. So basically what the Court of Appeals says, if I could paraphrase, is that the trial court got it right. You over-litigated. It denied you attorney's fees because of the tactics that you chose to use in this 5-day trial. So sorry, you're going to have to pay for your own fees.
Correct, yeah. So I think the standard of review for a denial of attorney's fees based on 2030 is abuse of discretion. And the court, I think, cited 2 or 3 examples of what Daniel did to over litigate and cause the trial to drag on. It was questioning the accuracy of translated documents, and suggesting one thing on day 1, then taking a different position on day 2, and they gave really concrete examples of exactly what he did.
Yeah, with regard to the translation of documents, the Court of Appeals stated, or maybe it was the trial court, I think it was the Court of Appeal that stated, you could have gone out in the hallway, right? And you could have figured this out besides the trial. If there was any question about the translation, which ended up, being proper, you didn't have to waste days getting somebody in here to do that.
Exactly. I think the court said they stipulated to the translator. So in the days leading up to the trial, there's no reason why he couldn't have resolved this issue with the other side.
could have said, hey, we're going to have a joint conference call with the translator, and I've got some questions about some of the wording and stuff, and just kind of gotten instead of making a big, circus out of it.
Yeah.
So I think that this has a lot of application to people that are in family court. I could think of some cases that I've recently done. I did one where I was going against a person representing themselves. We call them pro pers. And what should have been maybe a day trial, on some very limited issues, ended up being like a 4 or 5 day trial. And, everybody in the courtroom just sat. And the judge was very patient with this person. And he just went on and caused so much delay because of his tactics. He didn't know what he was doing, but he was also doing things that were really underhanded. So I think it applied to, pro pers can't get attorney's fees anyways, right? So that wouldn't apply there. It would apply if an attorney, I guess, is the one that's doing all this. Now, in the case that I talked about the pro per, now we're asking for him to pay my client's attorney's fees for having to delay that. And I guess that's a different day that we could talk about that. But the issue is the same, and that is bad tactics, delaying the proceedings. And, it's like I said at the beginning of this, it's not a game, right? The court is not an opportunity to see if you could trick the judge by putting in false evidence or something like that.
Well, this reminds me of a case you and I tried a few years ago where the other side brought in like a whole year's worth of text messages, and they exchanged it with us only 2 days before the trial, and then went through every single text message for an entire year. So it reminded me of that.
Or how about this tactic is trying to introduce into evidence an exhibit such as, let's call it a Facebook message, and purporting that it's something than what it actually is. And that, and you're just hoping the judge doesn't look carefully at the exhibit, or arguing that messages that came from just regular email messages, that there's a pattern of behavior and the email messages don't support that. A videotape, a video recording of an incident that occurred, and claiming that the video is going to show something different than what it actually does. I think that people think that family court is like being a criminal defense attorney. When you represent people in the criminal world, you get to use a lot of fancy defenses, right?
Technicalities.
Yeah, and everybody, pretty much acknowledges that that's okay so long as you're being honest and ethical. But you could come up with some interesting theories to defend somebody. You see that in the really serious cases. My client was mentally insane, and all this stuff. In family court, it's about giving the judge information to derive a just decision. To come up with good results. We advocate strongly for our clients, and we know, the trial tactics that are proper. But when you're misleading the court, and they didn't really talk about this so much about the misleading the court, but that's what he was doing, right?
Right, which is so scary because sometimes, unfortunately, people fall for it, or you're sandbagged and you don't have enough time to dispute this evidence that's coming in that's not trustworthy, and it has an effect on the way the court makes the ruling.
Yeah, I think that's the most important part of this, is that there is a danger in family court that the judge could get it wrong because of the lack of timing, or somebody's not presenting accurately as far as the defending against it, and there could be a bad factual finding because somebody is cheating, basically.
Yep.
Well, cool. Well, I think this was a good decision to hold on to. We do come across on occasion cases where people are over litigating. What you say is we like to bring our cases to a settlement conference. You and I have done so many over the past 6 months. I'm losing track of them. Fortunately, we've settled every single one of them. But, a lot of times that's forced on the other side because the other side wants to continue on and stuff. And then we have to reason with them that, look, going to trial is not going to make sense here, right? Well, thanks again.
Thank
like
you.
I said, this was a difficult case, and we got through it. So
This was fun.
okay. And thank you for joining us. See you next time.